call today. I just want to thank Joshua Kaddish and Lisa Tonini, both from Fluxman's. Lisa is a director there, Joshua a senior associate. All the other Fluxman's people who've come on the line, thank you very much. I think today is going to be a very relevant call under the current COVID situation, landlord-tenants' rights and force majeure clauses. So without further ado, I'm going to hand it over to Joshua to start off. Thank you very much, Joshua. Let's go for it. And please, could you all mute and turn your video off so we can get the feed going nicely. And we're going to have a couple of polls during the thing, and there's going to be a couple of questions. So if you could please be as interactive as possible. And if you've got questions, start putting them on the chat, and at the end we'll start answering whatever questions we can and see if there are answers from our panel. Thank you very much.
Thanks, Anthony. So please, if everyone can bear with us, it's the first time we're presenting on a Zoom type conference, and on top of that we've got some slideshows for you. So what could go wrong? But we're going to do our best. We were given this opportunity to present to the EO members, and we're very excited because irrespective of what industry you're involved in or what role you play in your business, the COVID-19 pandemic's affected you in some way. Lisa and I are hopefully going to be addressing you today and enlightening you on what your legal rights might be, particularly in relation to some of your commercial contracts. Maybe at this point, let me share my screen and take you through. I've got a short slideshow. After that, Lisa will also be addressing you, and then hopefully we can open up the floor and answer some of your questions. There's also going to be an interactive poll, which you'll see popping up on your screen. As you see it, if you can just fill it in, we'll get the results, and it might help us better understand sort of what our audience is looking for, what your personal perspective and effect might be. So I'm just going to now share. Hopefully I can share my PowerPoint presentation with you if you'll bear with me. Okay, perfect. Okay, so to start off, what's a force majeure? I'm sure you've all heard this. It's a buzzword. We've been inundated with questions from our clients about this particular term or what it actually means. So just as a starting point, unlike other civil law jurisdictions such as France and Germany, the term force majeure isn't actually defined in any piece of South African legislation. It's commonly referred to as an act of God, but it's actually a French term, and it literally translates to, and it means superior force. You may have also heard of some Latin terms or read them in your contracts or agreements called abis maior, or even a causus fortuitus, and you might have no idea what it means. Hopefully by the end of this, we'll be able to better explain that to you, and you'll get a much better understanding. But basically, from a legal perspective, a force majeure is the general term that's used to cover all of these events. And what it means is it's an act of nature or even an act of man, which is unforeseen or reasonably unforeseeable and beyond the reasonable control of either both of the parties to the contract, and it makes it, or only one of them, and it makes it objectively impossible for one or both of them to perform their respective obligations in terms of the contract. Some of the more common examples which you might be aware of for force majeures would include things like wars, strikes, riots, plagues, hurricanes, floods, earthquakes, volcanic eruptions, etc. So the question is COVID-19 a force majeure event? It's very important to know that the courts and none of our legislation has set out a list of exhaustive events. There's no list which tells you what a force majeure is. It's our laws constantly reviewing and developing its position as and when new events emerge and as and when new court cases are brought before it. It's been widely accepted that events such as international pandemics, and most recently we saw this with the SARS and the MERS cases, these are plagues, and they're also commonly seen as a force majeure event. What's also very, very important to consider is that the COVID-19 went together with the nationwide 21-day shutdown. You need to look at these two things together when you're deciding whether this is a force majeure event. In short, we believe it is. Between the outbreak itself and the actual shutdown and the lockdown for 21 plus days, that would constitute a force majeure event in terms of our law. Okay, so now the next thing you might have heard, your tenants or some of the other parties to your agreements might have referenced a force majeure clause, or even may have asked you whether there was a force majeure clause in your contract. So what is this? A force majeure clause are clauses which are not common in contracts, but they do appear. They all take different forms. And the idea behind them is that they specifically address and that they modify the contracting party's rights and obligations in terms of the contract. And they cater for instances where there's an extraordinary event which occurs, which is beyond the control of the contracting parties, and it prevents either one or both of those parties from actually fulfilling their obligations. The issue with these clauses is that when you read them, you'll see they're usually quite widely drafted, and they encompass an array of circumstances. They'll often give you a few examples. You need to decide whether you believe that this COVID-19 pandemic actually falls under or falls within the ambit of your force majeure clause. Depending on the actual drafting and the language, there might be a variety of consequences that this clause sets out. It can depend sort of on what the party is affected by this, how long they're affected for. In some situations, it excuses that party from any consequences of delaying. It can allow them to suspend the contract, and in some unique situations, it can even allow you to terminate the contract as long as it subsists or persists for a certain period of time. So it's very important that you check this clause very carefully and that it's interpreted correctly to decide what each of the parties' respective rights and obligations from it would be. Something that's very important to note is that the party that's actually seeking to enforce and to invoke that force majeure clause, they will always bear the burden and the onus of proving that the event or circumstance actually did give rise and did actually trigger that clause. That's just something to bear in mind before you rush out to try and trigger it. Okay, so the next question is, now that you know what a force majeure clause is or might be, what happens if there isn't one in your contract? And this is the case in the majority of contracts. Don't be alarmed. Most contracts won't have this. And to be honest with you, very few people would have contemplated something like a world war, a global pandemic, or a national shutdown. So the chances are it's not there. What this means is that you're not bereft of any rights. What you do is you'll follow your common law position. The common law sets out certain rights and remedies, and we're going to have to leave the contract itself, depart from the terms of the contract, and we're going to have to interpret whether the common law would actually apply to the situation. So just to set out some general principles of a contract. In order for a contract to be valid, apologies, I just want to close this. In order for a contract to be valid, there's certain requirements that must be met. The first is that there must be consensus between contracting parties. The parties themselves must also have capacity to contract. The agreement must not have any certain or definite terms. Sorry, it must have certain and definite terms. The necessary formalities of the contract must be observed. The agreement itself must be lawful. The content of the agreement must be certain. And of most importance, the contractual obligations must be possible of performance. This relevant requirement is what's most important for our discussion. In terms of our common law, there's a doctrine known as the supervening impossibility of performance doctrine. What is this? This takes place in situations where an event occurs or supervenes after a contract itself has already taken place. And it's an event where objectively it renders the rights and obligations of the contract no longer possible of being performed. Just want to move my slideshow, apologies. The two of the most common examples are vis maior or causus fortuitus. Vis maior is commonly known as an act of God. That's something that happens like hurricanes, floods, lightning, things like that. Causus fortuitus is an intervention by the state. So if we look at it, the COVID-19 pandemic is a good example of an act of God, whereas the 21-day nationwide shutdown is a causus fortuitus. So in either event, this on the face of it would trigger a supervening impossibility. But what we need to do is we need to now look at the seminal case, which is the Peters, Flamin and Company versus Kokstad municipality case. This case occurred in 1919, and this was where the then appellate division had to adjudicate on a matter where a company entered into a 21-year contract with the Kokstad municipality to keep its street lamps lit. It managed this without any trouble for more than 10 years, at which point World War I broke out. The company was run and staffed by German nationals who were, as you can imagine, designated enemies of state and were eventually incarcerated as enemy subjects. The company was handed over to and wound up by the state. Because the company wasn't able to carry out its contractual obligations, the Kokstad municipality sued its members for a breach of contract. The court held that owing to the fact that there was a supervening impossibility of performance based on the circumstances, the performance were objectively impossible in the circumstances, and the company's failure to perform was actually excused. The law is, however, quite strict in the sense that it doesn't excuse the performance of a contract in all cases where a force majeure event occurs. Our courts have pronounced that there are some key elements which must exist in order for a party to successfully prove that an event or circumstance actually gives rise to the supervening impossibility doctrine. So these elements are as follows. The event itself must have an effect of causing the performance of one or both of the parties' obligations to be objectively impossible. The impossibility must be absolute as opposed to it just being probable or relative. The event must have been unavoidable by a reasonable person and must not be the fault of either party. The event must have been unforeseen or reasonably unforeseeable in the circumstances. And finally, the event giving rise to the impossibility must, of course, occur after the conclusion of the contract. So at this point, it's important to point out that the mere fact that performance has become more onerous, more difficult, or even more costly does not absolve a party from performing its obligations. A common query that we're getting from clients is to say that their business is suffering a loss in revenue because of the COVID virus, and you know, can they get some sort of reprieve or some sort of indulgence from the other party under a force majeure? And that's actually the incorrect approach. That's a completely different scenario, and it's one that quite a few of you have asked questions about. We'll get to at the end, but that in itself does not give rise to the doctrine of supervening impossibility. A change in your commercial circumstances, which might render your performance more expensive or even unaffordable, is insufficient to rely on this doctrine. Lots of people have fallen on hard times, and have had to make cutbacks, but that doesn't automatically mean that they can just avoid paying their creditors. Another important case which I want to bring up is the case of Transnet versus the owner of the MV Snow Crystal, because this was a Supreme Court of Appeal decision and was actually quite recent. The facts were briefly that a ship called the MV Snow Crystal was booked to enter the Sturrock dock in Cape Town Harbour and remain in the dock for about 2 weeks. The booking was made in June of that year, and the operator of the vessel had planned a schedule around that time. The Snow Crystal was, however, unable to actually enter the dock because it was being occupied by another smaller vessel at the time, whose owner flat out refused to move her vessel to the smaller Robertson dry dock, which was big enough to accommodate that vessel, but too small to accommodate the Snow Crystal. Although the dock master had power under the harbour regulations to give the owner of the smaller vessel 24 hours notice to vacate the harbour, he just simply declined to do so because he didn't want to upset the owner of the smaller vessel. The owner of the Snow Crystal sued Transnet for damages arising from a breach of contract. On appeal, Transnet attempted to rely on the doctrine of supervening impossibility, as it couldn't perform due to the actions of the other vessel refusing to relocate. The court did not entertain this defense, and they actually awarded damages to the owners of the Snow Crystal. The most important principle from this case is that the Supreme Court of Appeal stated that in each case, the court will take certain considerations into account. They are the nature of the contract, the relationship between the parties, the circumstances of the case, and the nature of the impossibility which is invoked by the defendant. So just to summarize the common law position, if after you've concluded a contract, an event occurs which causes the performance of either one or both of the parties' obligations to be objectively impossible, and that impossibility is absolute, as opposed to just being probable or relative, and is reasonably unavoidable, unforeseeable, and not the fault of either of the parties in the circumstances, then potentially a supervening event of impossibility may have occurred. So now the next question is, how is a force majeure triggered? How is the clause triggered? What do we do under common law? The important thing is that the force majeure clause normally isn't automatically triggered. A well-drafted force majeure clause will actually prescribe the required formalities that you need to carry out before you can invoke these provisions. In terms of the common law, as soon as an effective party is no longer able to perform because of what they perceive to be a supervening event of impossibility, they must give notice to the other party, and they must state that they're unable to perform due to the occurrence of that event of impossibility and the actual nature of why they can't perform. It's imperative that before you seek to enforce this clause, you get a legal practitioner to confirm that the provisions of the force majeure clause or even the principles of the common law actually apply. The reason for this is that if you don't, this could give rise to an inference that the party that's seeking to evoke the clause is not looking to perform its duties under the contract, which in turn could give rise to grounds for repudiation or a breach of contract. So what are the remedies available in the event that there is actually a force majeure? The general effect of force majeure is that for so long as it persists, it extinguishes the obligations owed between the parties. The effect of a partial or temporary impossibility of performance depends on the circumstances of the actual case. The general rule, though, is that the contract will be suspended until that impossibility disappears. If the supervening event goes on for an unreasonable amount of time, the creditor may then cancel the agreement. In the Peters case, the court held that if a person is prevented from performing his contract by vis maior or causus fortuitus, he is discharged from his liability. No action for damages from a breach of contract is available to that party, where the other party, to a party where the other party is unable to perform, resulting from force majeure, but the innocent party may actually have a claim for unjustified enrichment if such party continued to perform in the case of reciprocal obligations. So therefore, an occurrence of a force majeure event may, in some circumstances, suspend or even terminate a party's obligation under contract, provided that that party can prove that a supervening impossibility of performance actually occurred. In conclusion, the ongoing coronavirus contagion is having an unprecedented impact on trade and commerce. Some businesses may seek to rely on, or conversely oppose, attempts to rely on a force majeure clause or other contractual rights for relief from the performance of certain obligations due to the impact of this coronavirus outbreak. It's imperative that before doing so, you consult a legal practitioner to review any commercial contract you have to advise you on the existence and the applicability of your force majeure clause, as well as all your rights under the common law. Thank you so much for listening and letting me address you all today. I'm going to answer some questions later. In the meantime, I'd like to hand over to Lisa, who's going to take you through a little bit more and specifically address you on some property-related issues.
Hello. Thanks, Joss. That was very informative. The topic of my presentation is the effects of the lockdown on parties' abilities to honor their obligations in terms of their agreements and the extent to which the South African common law may assist them. So, as we all know, on the 15th of March, a national state of disaster was declared and followed by a nationwide lockdown for the period 26 March to 16 April at present, effectively prohibiting the operation of non-essential services. During the period of lockdown, by reason of the restriction of movement of persons and products, all non-essential businesses shall cease operations and all shops and retail malls closed. It is contended that this lockdown constitutes a temporary supervening impossibility of performance. The reasoning in our common law can assist us in dealing with our present situation and the effect of the lockdown on the obligations of landlords and tenants. The case law I intend to take you through demonstrates that the solution proffered here is drawn from well-established writers and leading judges of our times. We're in good company in this regard. Until the 1919 case of Peters, Flamen and Company versus the Kokstad municipality, to which Josh has referred, the South African law, unlike English law, provided that supervening impossibility was no basis to excuse non-performance in a contract. In the Peters case, which was succinctly summarized by Josh, the court found that if a person is prevented from performing his contract by vis maior or causus fortuitus, under which would be included such as an act of state, in that case the internment of Peters and Flamant, the tenant would be, or the person would be discharged from his liability. The fact that the vis major or casus fortuitus has made it uneconomical for a tenant to perform does not mean that it has become impossible for him to perform. See, for example, the matter of JCI versus Mendelssohn and Bruce, where a shopkeeper argued that during the Anglo-Boer War, there was a drop in trade in his stationery business. The court held that in this matter, that a rental remission would only be countenanced if he was presented from trading, and that a mere drop in trade would be insufficient. The effect of the partial impossibility depends on whether, 1, an obligation is divisible from a contract and has become altogether impossible of performance, or 2, an obligation forming part of an indivisible contract has become impossible for full performance. In the former, the divisible contract must be divided and the impossible part discharged, the rest remaining in operation, and in the latter, the creditor must enjoy the option of cancelling the contract or accepting the reduced performance in exchange for the reduced counter-performance. This occurred in the matter of Stanfeld versus Kuhn, where in a contract for the sale of land, a vis major in the form of an expropriation for a national road made it impossible to transfer more than 0.471 of a hectare, and the buyer was held entitled to demand the 0.471 of a hectare against tender of a proportionate share of the purchase price. In the world leisure matter, which I will refer to below, it was found that temporary impossibility of performance, which we are dealing with here, does not in itself bring an end to a contract. Turning to the judgment of the full bench consisting of Kluter, Bleeden and Milan in the World Leisure Holidays versus George's matter, it was held that there can be no hard and fast rule. I quote, "In every case, a value judgment based on objective criteria will be required to establish whether it is just that the bargain should, to the extent still possible, be upheld and the obligations of the parties adjusted. On the other hand, the court should not make new contracts for parties. Neither party should be allowed to escape its obligations where the essence of the contract is still capable of performance." Now, turning to the question of agreements of lease. It is an essential term of an agreement of lease that the landlord must allow and enable a tenant to enjoy undisturbed use and enjoyment of the leased premises. If this does not occur, say for example if a shopping centre is closed for repairs, it can as a general principle be argued that the tenant will, for the period of time of the closure, not be obliged to pay rent or at least enjoy a reduction in rental. It is at this juncture important to have regard to the Roman Dutch writers, van der Linden in particular, who stated, and I quote, "A lessee or the lessee is entitled to demand the entire remission of rent or an abatement of part, according as he has had no use of the thing let during the whole or part of the time of the lease, unless this has been occasioned by his own act. To this head also appertains the case when through inundation, tempest, or such other like unavoidable misfortunes, the land has produced nothing." Grotius, another Roman Dutch writer, goes further and says, quote, "If by unexpected misfortune, such as war, fire, and unfruitfulness, or something of like nature, the lessee has been hindered in the use, then the rent must be reduced in proportion. End of quote. In the case of Stock and de Jong versus Kaplansky, it was held that plague at the leased premises, which led to the closure of the premises by the government, depriving the tenant of the use and enjoyment, will constitute casus fortuitus. By applying these principles during our lockdown, the COVID-19 pandemic can be seen as a casus fortuitus, and the closure of leased premises would constitute a vis major. In order to rely on these principles, a tenant must show that it did not have the use and enjoyment of the premises, the occurrence was unforeseen, uncontrollable, and the direct cause of the of the inability to fulfill the obligation to pay rent. Most commercial lease agreements do provide that a tenant will be obliged to pay rental without deduction or set-off. However, the Appellate Division, in a judgment handed down by de Villiers CJ in the matter of United Mines of Bultfontein versus De Beers Consolidated Mines, it was held that a prohibition of set-off can only apply to deductions or abatements that were in the contemplation of the parties at the time that the lease was executed. In his judgment, de Villiers CJ relied on the writings of the Roman Dutch writers I mentioned previously. It is therefore arguable that the current pandemic and resultant lockdown were not foreseeable. Therefore, clauses to this effect will not, it is suggested, assist landlords in resisting claims for a remission in rental. This judgment was upheld in the later case of Strauss versus Van Zyl. As to whether the common law prevails over force majeure clauses, the courts confirmed in the case of Airports Company of South Africa Limited versus BP Southern Africa Pty Limited that the terms and conditions of a contract dealing with force majeure events and the agreed consequences thereafter will take prominent precedence over the common law. Accordingly, it is imperative that the terms and conditions of each individual contract be properly scrutinized. And in conclusion, I wish to reiterate the dicta of Pluto J in the World Leisure Holidays case, where it was held that in every case, my emphasis, a value judgment based on objective criteria will be required to establish whether it is just that the bargain should, to the extent still possible, be upheld and the obligations of the parties adjusted. End of quote. For those of us wearing the hat of a landlord, attention must also be drawn to the mitigating measures introduced by the Department of Trade, Industry and Competition on the 24th of March in terms of Government Gazette number 358. The measures have the effect of relaxing the rules around certain provisions in the Competition Act, which will allow, through a block exemption scheme, retail landlords to work in consortium in dealing with issues presented to them by the COVID-19 pandemic. The new rules will apply to agreements in respect of payment holidays and rental discounts, limitations on evictions, and on the suspension or adjustment to lease agreement clauses that restrict the designated retail tenants from undertaking reasonable measures required to protect viability during the national disaster. Note, however, that this exemption must extend to all South African retail tenants in designated retail lines, namely clothing, footwear, and home and textile retailers, personal care retailers such as hairdressers, health and beauty salons, and restaurants. Lastly, I understand that the chairman of the South African Real Estate Investment Trust announced in the press recently that there is to be a scheduled teleconference meeting next Monday of property industry stakeholders in order to come up with a response to the current challenges facing landlords and tenants. That concludes my part of the presentation. I think we are open to questions.
Thank you very much, Lisa. Thanks, Joshua. Joshua, there's a few questions I sent you which were sent on the WhatsApps. Can you maybe address those between you first, and then we'll see what other questions you've got?
Sure, 100%. So the first one was sent, I think, by Andrew Cook. Andrew writes, I would like some guidance on some of our large clients claiming force majeure in their annuity contracts for software licenses. They are locked into 24-month contracts. Their feedback is that they cannot open their doors, specifically the retail and motor industry clients. Can they do this, and what retaliation or defense do we have if they do? I'm not sure whether Andrew's on the call, but the general advice would be regarding this particular example. Any software licenses, we first request start of his terms and conditions for the software license. We would look whether contractually there's any force majeure clause there. If there is, we would be guided by the force majeure clause. As Lisa pointed out correctly, in the BP case, the common law would, the terms of a contract will prevail over the general common law approach. So that would be our first step. To the extent that for whatever reason there isn't a force majeure clause in the terms and conditions, we would then move over to common law. So as I discussed earlier, one of the basic requirements for a valid contract, after it's been concluded, there must be possibility of performance. Where there's no possibility of performance, the party that cannot perform needs to allege that some sort of supervening impossibility of performance occurred. All those factors and those requirements I took you through need to be satisfied. In this particular example, it sounds like the feedback from the client is that they can't open their doors, not due to the fault of anything to do with Andrew's company. There's been some circumstances and some commercial changes in their business which has rendered performance more costly or very difficult. But it's not because of the software license or anything to do with Andrew. The assumption that I've got from this message is that Andrew is still performing. Andrew is still able on his side to perform all his obligations. So for that reason, I would say that this contract is still completely valid. It would still run. There's no temporary extinction whatsoever of the obligation to pay in this instance. Where Lisa brought up a lease agreement and where a lease might be different is that a landlord can't, if you're not an essential service provider, a landlord can't currently provide certain tenants with beneficial occupation of the premises. That's a fundamental of a lease agreement. And in that circumstance, the tenant can certainly argue that there's been a supervening impossibility of performance. Sorry, the landlord could argue that. And that would give rise to some sort of temporary extinction of the obligations. Maybe no rental being payable, rather storage costs, or maybe there'd be a deduction. That would depend on the circumstances in the lease itself. This example is very different. Here you've got both. You've got Andrew's company is still performing. It's still providing services. The only difference is that the client that he's rendering services to has gone through some sort of financial difficulty. In itself, while that might be a difficult situation, it's got nothing to do with the contract. And I would argue for Andrew, without having had sight of the terms and conditions, that Andrews would still have 100% claim to continue to receive any amounts under the software license. I don't know if you agree, Lisa. You muted.
I'm in agreement, Josh. I think the principles that you explained in your presentation cover that answer pertinently.
Okay, if I can go quickly to the second question that we got last evening. It's from Chris. Chris writes that we operate a business which exclusively services the restaurant industry. We don't have retail space. However, without restaurants trading, we can't access our offices. We aren't deemed an essential because we're not deemed an essential service provider. Our landlords are still expecting us to pay full rental for the period rather than pro rata for actual time we can access. I'd like to know what kind of recourse or position we can have with this, as I don't believe our scenario is covered by the DTI Gazette to retail landlords. Lisa, I don't know if you want to tackle this one.
Yes. Certainly, I think that in that scenario, the DTR Gazette doesn't cover or doesn't assist Chris. But at the end of the day, if he is not able to operate because of the lockdown, in other words, he cannot access his offices, then the common law principles that we have alluded to will assist him in claiming a rebatement or remission on his rental payments. Do you agree, Josh?
Yeah, I do agree, Lisa.
Because I think that the DTR Gazette is very specific as to the parties to which it will apply. And as Chris points out, he is not in the restaurant. He is not he doesn't have retail space, and he doesn't operate a restaurant. So he would be hit by the general lockdown provisions, that is the closure of businesses and his inability to move to and access his premises.
I agree.
Anthony, were there any other questions?
Lisa,
Joshua, you've got other ones as well?
Yes,
Perfect.
I've got one from Andrew Cook. There's actually another one from Sean Gomez, which we can go back to, but this one from Andrew. Andrew asks, if a client asks you to sign a force majeure letter, are you impacting any of your rights to recover their debt? Should the letter have an end date, i.e. when they are no longer able to hide behind the force majeure clause? And are we able to pass the impact down the chain, i.e. to our suppliers? So maybe if I can kick it off. So Andrew, just so you know, yes, so where you do sign a force majeure letter, it will be binding provided that you both parties to the agreement sign it. In your original agreement, you will most likely have some sort of non-variation clause, which will state that any amendment to the agreement needs to be placed in writing and signed by both parties. So the second that you pen this letter, you will be impacting some sort of rights to recover the debt if you had those rights under the agreement itself. So you've now gone and you've varied the original agreement. Obviously, we don't know your exact circumstances, but you say, should the letter maybe have an end date when they're no longer able to hide behind the force majeure, and are we able to pass it down the chain? I think that's a difficult question to answer generically, but basically, you'd have to scrutinize and look at each one of those transactions in the chain. You would need to see whether there's been an impossibility of performance or whether each one of those particular transactions along the chain have a contract which has a force majeure clause in it, which would stipulate how to govern that position. In terms of an end date, the common law says that where a force majeure persists for an unreasonable period of time, that can give rise to a cancellation of the agreement. It will also depend on what the actual agreement itself is. Whether it persists for so long that possibility of performance under the contract actually can't ever happen, then it would terminate the contract. Where it persists for 21 days, for example, and thereafter you can resume, it would be a 21-day suspension, provided obviously that you've complied and you satisfy all the common law remedies. There'd be a 21-day suspension of the contract. It doesn't mean that all rights, obligations in the contract itself is set aside. What you would do is the specific performance that cannot be performed because of the supervening impossibility, which is the COVID-19 pandemic and the shutdown, that would temporarily be extinguished. After the 21-day shutdown, this would continue, and there wouldn't be a claim for breach or damages. But I must just say that we would really need to consider and understand the particular set of circumstances of the transaction to be able to give you an answer to each one of those series and to scrutinize any contracts that you might have, because it's possible that there is some sort of force majeure clause in place which would override your common law remedies.
Okay, thanks, Joshua. Okay, so next one I've got here is from Aviv Sachs. From my understanding, in terms of a lease agreement, in the absence of a force majeure clause, common law prevails and therefore no rental is payable. Please define what a rental rebatement or remission means. That is different from a rent holiday when the rent is still payable, but over an agreed period of time.
Right, so can I tackle that?
Sure.
A rental rebatement or remission, I believe, refers to a reduction in the rental that would be due. And I think that the rent holiday is a colloquial term that we use to explain that very concept. So a tenant is obliged to pay rent, generally speaking, in monthly installments, and a rebatement would really consist of a reduction in that rent for the period during which the impossibility of performance or the supervening impossibility persists.
Thanks a lot, Lisa. Then there was one from Arnold Shapiro. With due consideration to the legal principles outlined, can a tenant unilaterally withhold payment in a letter globally to all landlords? Is there not a principle that leases must be prepaid? So this is an example where a PEP or a big corporate has sent out a letter to all their landlords saying they're basically not paying.
So yes, generally rent is payable upfront at the beginning of every month. But in terms of the principles that Josh and I have espoused in this presentation, there is an argument to be made that you can withhold rental as a result of a supervening impossibility of performance. But I think it's important, and I don't think Josh and I have emphasized this enough in our presentation, that at the end of the day, the best case scenario is to approach your landlord and to enter into some form of discussion or negotiation regarding your inability to pay rent. It doesn't bode well to simply withhold the payment of rental or to simply address a letter to say we're not going to pay. I think that it is important to engage with landlords and really to try and reach agreement on that issue. But certainly where there is a supervening impossibility of performance, it is our contention that you are entitled to a rebatement or remission in the rental, a reduction, a non-payment.
So Lisa, if I can just expand, and there are just 2 points which I want to make very clear. The first is we're using the words remission or withholding or deduction or set off of a rental, but in reality what I just think everyone needs to get clear in their mind. The argument being put forward by a tenant is that the landlord is not able to comply with the terms of the lease. The basic principle of the lease agreement is that a landlord needs to give beneficial occupation to its tenant. To the extent that a tenant is not an essential service provider, the tenant cannot lawfully occupy the premises. The regulation that was promulgated and that the president gave in terms of the 21-day shutdown made it illegal for certain tenants to even exit their residence. So what that means is that they cannot lawfully occupy the residence, and the landlord in turn is not performing under its obligations in terms of the lease. It's not the fault of the landlord, but the facts of the matter are that they are not actually performing. So therefore, they're not complying with one of the fundamental requirements of a contract. In turn, the landlord's argument would be that the reason that they aren't performing is the same as if there was one of an earthquake or world war or some sort of natural disaster or pandemic. It's something that's impossible, it's supervening, it couldn't have been foreseen, and it's not due to their fault. But what the effect of it is that what it will do is temporarily suspend the obligation of the tenant to pay rental. It doesn't mean that they don't have to pay anything, and it doesn't mean that the lease itself is set aside. There's a strong argument to suggest, and we agree with it, that if you're a tenant and you're storing equipment, your servers, your desks, things like that, sort of on your landlord's premises, the landlord is still securing that. You are still getting some form of occupation. There might still be security services being rendered. There might be some sort of consumption charges that are still being paid by the landlord. So there is some performance that's happening from the landlord, and the landlord will be entitled to some sort of compensation for that. But when it comes to a pure rental, it's not that the rental is necessarily being withheld. The argument from the tenant side, the legal argument, is that it's not actually a legal obligation to pay the rental because it's been suspended because it cannot have beneficial occupation. So I think everyone needs to get that clear. We use terms like rental remission. When it comes to a payment holiday, that's something that the landlord and the tenant might agree on outside of the confines of the agreement or outside of the law. But the point is that you need to get it crystal clear in your head if you're a tenant, that you're not withholding, you're not deducting, you're actually saying that this rental was not due. It has not become legally due. and that's due to the non-performance by the landlord. So I hope that point's a little bit clearer. The second thing that I wanted to address with leases sort of advice, and it's an advice that we've given most of our clients. It's a grey area. There are a lot of grey areas at the moment in terms of COVID and in terms of our law. There are tenants that are facing massive cost constraints. They're struggling to pay their employees. They may or may not be able to invoke a force majeure clause if it's in a contract. They might think that they can invoke the common law principles. Whether that's true or not, we're not sure. The point that we've made is that the first step should be that both parties are familiar with what the terms of their lease agreement is. The second step, before even instituting any form of legal action, set up a meeting with your landlord or with your tenant and discuss what a fair scenario would be. Payment holidays are being suggested by a lot of landlords because it gives you a period to trade out of whatever the effects of COVID will be, but it still means that the landlord will at some point get compensation. One should also be aware of the fact that if you levy interest on it, you need to be aware potentially of other legislations. You need to be aware of the Consumer Protection Act as well when it comes to certain contracts dealing with consumers who are individuals or juristic persons with below the determined threshold. So there are a lot of legal implications that need to be thought out. The first step we would say is that you liaise with the other contracting party, and thereafter you seek legal advice to confirm that the settlement that you're putting in place is actually valid and it is legal. Because if it's not, it will be completely unenforceable. And if the SCA comes out with a decision that's adverse to it, you might be faced with some sort of legal consequence or remedy. There might be an unjustified enrichment claim. So it's very important that after liaising and engaging meaningfully with your other party, get an attorney to just check that transaction, that agreement, that settlement is 100% correct and legal, and get us to formalize it in a formal written settlement agreement. So you've got it in writing. It's not just a verbal thing over the phone, and in 4 months' time, one of the parties find out that they might have actually got done a bad deal and they say that there was undue influence or they weren't guided correctly. So that's really our practical advice. That's sort of our overall advice to all parties.
Great. Thank you, Joshua. Okay, next one. We are a service
Anthony.
office company.
Anthony,
Yes.
sorry. I just wanted to add a litigator's perspective to the conversation. Richard from Flaxman's. I'm a director in the commercial litigation department. When penning such a letter, I think Josh has made a very good point. You really need to watch what you write in penning such a letter, because if you say, I'm unable to pay my rent, it may be taken as an act of insolvency. So you should really word it in the sense that I am able to pay my rent, but because of COVID-19, I'm not going to pay my rent. And that will take you out of the realm of act of insolvency. And that's really what I wanted to add.
Thank you very much for that that advice there. Okay, so next question. We are a serviced office company. We have secured an essential services certificate under the classification accommodation. While we have remained open, many of our clients, also businesses, are unable to utilize the services and space that we provide and for which we are contracted by them. This is as a result of the business not being considered essential services. Do they have any rights in law not to pay these contractual services and space for the period of the lockdown? Joshua?
Yeah, sorry, I'm just catching up on the text. Lisa, I don't know in the meantime if you have a thought to that. There's quite a lot to consider.
Yes, I think that what's important in that question is that as I understand it, the accommodation is regarded as or the offering of accommodation is regarded as an essential service. So that business is able to operate. But their clients or people who had contracted to take up accommodation are unable to do so and cannot pay for space. And I think that falls within the realm of the Mendelssohn case, that for the accommodation business, they can operate, and that there is a reduction or downturn in their turnover. I don't believe that the lockdown assists the accommodation business. I'm just thinking off the top of my head.
So I think if I understand the question correctly, and please, if you're on the call, correct me if I'm wrong, but the client, so the party on the call is in the accommodation business, but some of their clients are non-essential service providers. And as a result of them being non-essential service providers, they're not able to utilize the services or receive the services for whatever reason. So if that is the case, if I'm correct in that, it goes to what we said earlier. Then there could definitely be an argument that performance is not possible. The reason is that because of the shutdown, it wouldn't be legal for the other party, the client, to actually be able to receive the performance. And in that event, there could be definitely an argument to say that during that time, during the 21 days or however long the lockdown persists, we wouldn't be paying because the contract itself doesn't entail performance for that perspective. Any performance that is rendered or can be received partially, if it can truly be received, they should attribute some compensation to it. But if they are unable to access the premises or access the services or whatever is being rendered because of the shutdown, there's certainly a strong argument to say that they wouldn't be liable to pay it, certainly for that period, temporarily.
The only thing, Josh, is that as I understand the question, the accommodation business can still operate because that is an essential service.
Yes, but their clients can't.
But their clients can't.
So their clients are the ones that are saying that they don't want to pay, if I understand this correctly.
Yeah, but the business can still contract with other people who may be able to pay.
Certainly, and other essential service providers would obviously not be exempt. It would depend on the circumstances. If we could understand that scenario a little bit better.
Brad, are you on the line? Would you like to clarify anything there? Okay, not there. Okay, James Adams, I want a commercial retail space. One of my tenants is a hairdresser. She cannot operate due to lockdown. Do I have to waive rent as she cannot operate? I take it this falls under supervening impossibility. Do I have any recourse against them? Can either party cancel the contract?
Okay, so that's a good question. It's similar to what we've discussed. It sounds like the hairdresser obviously wouldn't fall under an essential service provider, and they can't legally take beneficial occupation. So they would definitely have an argument. The first thing I would say is there a lease agreement or some sort of agreement in place? And we would need to scrutinize whether there's some form of force majeure clause. Let's assume there isn't. If there isn't, we would move to the common law principles. In terms of the common law, I would agree that there has been a supervening event of impossibility, a causus fortuitus, which is the lockdown and the COVID virus. That it can't just be that obviously the hairdressers decided that because clientele don't want to come in and get their haircut during this period, they're not willing to pay. It has to be for the period of the lockdown. So anything before or after is irrelevant for the purposes of this. They still have to pay, irrespective if they don't even have a single customer. But when it comes to the actual lockdown itself, there would definitely be a strong argument to suggest that they wouldn't pay rental. See, the word waive was used. That's not the correct approach. You're not waiving your right. The truth is that the landlord isn't due any rental because the tenant isn't able to occupy. So it's supervening impossibility. It's not a waiver of a right. The other thing that needs to be borne in mind is that if there are things like the hairdresser has their chairs and their equipment and certain things which are taking up some sort of the premises and they're being stored securely on the premises, there can definitely be an argument by the landlord that some compensation should be received. It also wouldn't entail them to an entitled cancellation of this lease. I don't know how long this lease is for, if it's month to month, if it's verbal, if it's a long-term written lease. But the truth is that it should just be temporary. It should just be 21 days. And after that, both parties will continue as they were. I would suggest in this scenario, the landlord engages with the hairdresser, discusses this and informs them of what the legal position is. And they come up with some sort of scenario whereby the landlord receives some compensation for storage costs or any other services that they might be rendering. But they need to bear in mind that there's a very strong case by the tenant to not pay rental.
If I can just add on that particular case, I'm in agreement with you, Joss, that the World Leisure case is really authority for the proposition that impossibility of performance, which we would be dealing with in this instance, does not in itself bring an end or an immediate end to the contract. So the last part of the question is, can either party cancel the contract? It doesn't come to an end because of the lockdown. What we're really saying is that the obligation to pay rent is suspended for the period of the lockdown.
Thank you very much, Lisa. Okay, the next one. Surely an independent party judge arbitrator would need to make a ruling that the IOP is applicable for a 21-day lockdown, and thereafter the tenant would be entitled to relief. If rental is payable up front, then there's no reciprocity. Delivery of space is after the payment of rental. It's got you guys quiet there.
Yeah.
Just considering it, yeah. Lisa, I don't know what you think.
Well, I don't think it's correct to say rental is payable up front. If rental is payable up front, there's no reciprocity. Delivery of space is after the payment of the rental. I think that you need to look at your agreement of lease, and there are reciprocal obligations on the tenant's part to pay rent and on the landlord's part to make space available. And if that space isn't, if the tenant is not able to use and enjoy the space, then we're suggesting that you are entitled to rely on the supervening impossibility of performance. At the end of the day, I think that, yes, it is correct that a judge would have to make a ruling, but that doesn't prevent a tenant from raising this issue during the time of the lockdown. I'm not really sure.
I think the principles regarding the principle that's being brought up is about paying in advance. So just because you pay in advance, it doesn't mean that what follows afterwards. When you pay in advance, that's a commercial term that's been agreed between the parties, but that payment entails and entitles you to performance by the landlord thereafter. The fact that there's been an interruption, notwithstanding that you paid before, it's like a deposit or paying something in advance, notwithstanding that there's an interruption thereafter, it doesn't really affect the legal position. The point is that, yes, the cash has flowed, the rental's been paid, but the rental can be applied to a different month. It doesn't change your legal position. It doesn't change your remedy. The point is that if the landlord can't perform, irrespective of when rental is paid, if it's paid in arrears or if it's paid up front, it doesn't matter. The point is that the landlord owes an obligation to provide beneficial occupation to the tenant. To the extent that they cannot, due to a supervening impossibility of performance, the tenant will still automatically, provided they can prove it, they'll still have that entitlement to that 21-day period not being a rental period. So I don't think that it matters whether the payment is in advance or whether it's in arrears. I heard Ara was trying to add to it on the line, I think.
Yeah, Josh, I think you're 100% right. I think the issue is that the tenant is paid in advance. Now the lockdown period hits, but he's already paid. So what happens to you? In those circumstances, either he's going to ask for a credit because he's entitled to the credit in the sense that he had no obligation to pay and he paid. Alternatively, he's going to look to set it off, depending on what his lease says, against future rentals.
Correct.
Thank you very much, Ara. Okay, we have 3 more questions. Let's wrap this up here. Firstly, we supply bulk timber to the lounge manufacturing industry. We have been receiving letters from our lounge customers that have received bulk timber from February to present saying to us that they cannot pay and don't know when they can pay.
Okay, so Rashad brought up a very good point earlier. When somebody writes you to say they can't pay or they're unable to pay, they immediately commit what's called an act of insolvency. Something to bear in mind. It's not necessarily answering the question, but it's just something to bear in mind. If you look at a contract, often you'll see that an act of insolvency might trigger a breach or it might trigger something that gives you a right to a cancellation for the other side. So people must really bear that in mind before they fire out these letters saying, business is difficult, I don't know if I can pay my bills, whether that's factually true or not. I don't know what's going to happen. By doing that, you're actually committing a legal act of insolvency. which has far-reaching consequences in many agreements, not just the agreement you might be discussing or negotiating with, but their shareholders' agreements and their other agreements where an act of insolvency can actually trigger an event, an unintended consequence. So just, there's something really to bear in mind before you fire out bulk letters to all your suppliers or to all your creditors to say, I don't know if I can pay, I probably can't, it doesn't look like I can. Don't do that. That's an act of insolvency, and it's something that Richard brought up earlier to say, before you do that, take legal advice about the actual wording of your letter, because you can have you might think that you're saving yourself by claiming a force majeure, but you're not. The second thing is, just because going gets tough and because your commercial business is suffering some sort of revenue issues because of COVID, like almost every business is, that doesn't automatically give rise to a remedy for you to not perform and to not pay. It sounds like this is more of a plea by somebody to say, I'm facing financial difficulty. The likelihood is that I am going to go under. Instead of that happening and you having to prove your claim under liquidation or an insolvency or something along those lines, let's rather come to some sort of agreement outside the parameters of what the contract is. That's something that's a commercial consideration, and it's something I would never put in writing either. It's something that should be discussed privately without prejudice between the parties. And once a settlement agreement's put in place, that then a legal practitioner can get involved and can give you advice on the wording and the terms and the consequences. But it's not something I would fire out, so I'd be careful of that. But just to give the answer there, just because you're going through hard times and just because their clients might be suffering and somewhere along the lines that they're suffering, it doesn't give you any legal recourse to escape from the contract.
Thank you very much. What recourse would landlords have with banks' bonds in terms of force majeure, supervening impossibility of performance? And then there's a second part, what percentage of rent is appropriate to charge for storage security? So I think the bank one's quite an appropriate one, because we've talked about the tenants and how can the banks say interest carries on rolling, but how can they force you to pay the interest if you're not receiving the rent? It's a tough one. Joshua, Lisa?
Well, in my view, that is distinguishable from a landlord-tenant situation, because the bank is entitled to receive payment in terms of bonds and loan agreements, etc. And they're not providing any premises or rental space or opportunities. The fact of the matter, unfortunately for the landlord, in my view, is that they will suffer a downturn in their income, but that doesn't absolve them from the obligations that they have with banks.
Yeah, I agree, Lisa. When we were unpacking the effects of COVID, and particularly when it comes to bonds, landlords, tenants, everything like that, the unfortunate realization that we came across is that from a legal perspective, there are far-reaching ramifications. There are going to be winners and losers in every industry and everywhere across the board. Unfortunately, for commercial landlords, it seems like they're going to be the losers. The reason I say that is because the banks have still performed. The banks have still given them the finance to acquire their property. The repayment shouldn't be interrupted because of the fact that they don't have a tenant. Just like that, let's say COVID wasn't happening and they were struggling to find tenants just because of the economy. That wouldn't automatically give rise to them having some sort of legal remedy to delay payments or for payment holidays or for no interest to accrue. It's the same thing, unfortunately, with COVID. Notwithstanding that their tenants might not be essential service providers and therefore not have to pay rent, it doesn't mean that you can knock that onto the bank. You should approach your bank. We recommend that you do. You should have conversation. It's not in their interest for you to not be able to repay your bond and for you to default and for them to execute on their property. That's not what the bank's looking to do, especially now. So you will have an opportunity to engage them on a commercial perspective. But from a legal perspective, unfortunately, it doesn't appear that you would have a remedy to go to the bank and to request any form of holiday or remission or delay whatsoever.
There is a second part to that question. What percentage of rent is appropriate to charge for storage and security? I would take a robust approach and say that, if there's impossibility of performance, in other words, you are not able to use the premises, that is the end of the matter. I wouldn't be looking for percentages.
Yeah, so I wouldn't pin it to the rental. It would more be a question of fact and what actually is being stored on the premises, what services are truly being given to the tenant during that 21-day period. And what you could do is either what we would suggest is that you engage the other party and you negotiate. You come up with an amount and you agree it. Failing them, you go to some sort of expert in the field that can ascertain for you what it would cost had you stored that somewhere else on a similar premises for a similar amount of retail space, and what would that cost be? It's a difficult one to answer, and it's one of the many things that isn't really legislated for. There's no legal answer to it, but it's something that if a court were faced with it, they'd have to take some sort of view of what would be reasonable in the circumstances, and you'd have to prove that.
So very similar to the one you just answered, can the landlord still charge a tenant share of rates during lockdown if tenant sees inability to pay due to supervening impossibility of performance?
I think that the answer previously given deals with that.
Totally, yeah. Okay, Ilan Kaplan, you're out of line. Is Fluxman going to pay the April rental? That's quite an interesting one, but we'll leave that one for now.
Well, I think we can just say that we are talking to our landlord. So just to reinforce the point made very well by Josh, is that this is the time to be in discussion with your landlord and your tenant. And, you know, the best advice we can give is to really try and reach an agreement that suits both parties.
Okay, great. And does force majeure IOP apply to all types of commercial contracts?
Absolutely. So firstly, some commercial contracts might have an actual force majeure clause, some might not. If it doesn't, don't sweat. It doesn't mean that you don't have any remedies. It means that you have to go under the contract, under the common law remedies available. It's irrespective of the type of commercial agreement you have, whether it's a lease or another one. The point is, the very important part though to consider is performance impossible because of the COVID-19 and the lockdown? So has this supervening event caused impossibility? That is really the question. If the answer to that is yes, and you go through some of those other questions which I gave you in terms of the requirements, like whether it was foreseeable, whether it's absolutely impossible as opposed to just reasonably, all those type of questions, if you can satisfy that test, you more than likely have a common law remedy. But the most important question is, don't worry about the nature of the contract, worry more about the question as to whether performance is truly impossible.
Thank you very much, Josh and Lisa. Really, really appreciate you guys doing this for us today. I hope we answered some of the questions for people out there, and hopefully we can do one or two of these on other topics in the future. And if Lisa, Josh, you could just stay on the line. Thank you very, very much, everyone, and have a great day. And hopefully you go and sort out your tenant-landlord issues and go talk to those landlords or tenants. Thank you very much, everyone. Goodbye.
Thank you so much.
Bye. Josh, you were brilliant. Well done.
Thanks, Lisa. You too. It was awesome. It actually went nicely. Once you get into it, it's really nice.
Yeah.
Let's just get everybody off the call first.
Okay, thanks. I just want to quickly, but if you don't mind, I just wanted to ask Josh something. It was just regarding the loans with the banks. I'm just trying to view it. Is that seen as a commercial contract? And in the case where you have a single property, a property with a single tenant that is now not able to pay rent because of not having the occupation of the property, there's obviously no income for that property, and therefore there's inability by the landlord to pay the rent, the repayments on that particular property.
So your first part to answer the question, so the loan is a commercial agreement. Force majeure would be applicable. The issue is that notwithstanding that there's a knock-on effect in that down the line, the tenant probably would have a good claim to not pay its rent under force majeure. The problem is that the landlord themselves, notwithstanding they might not be earning any rental during that period, the bank has already provided them with that loan funding, which enabled them to buy the property and of which they've probably got security over. The bank has complied with its obligation. Its obligation was to lend and advance the money to the borrower. did that successfully. This supervening event of impossibility under the national shutdown didn't interrupt that. What it is interrupting is the landlord and tenant relationship as opposed to bank and landlord relationship. But unfortunately, it wouldn't give rise to that. What our clients are finding though is once they've approached their banks and they've told them that there's this issue and that their tenants aren't going to be paying, most of the banks have been more than happy to engage them meaningfully and give them some sort of payment holiday or waive interest for that period. Almost every client that we've had that's had this type of situation has come up with some sort of pragmatic solution with their bank. The last thing the banks want at the moment is for companies to default and have a wholesale auction of all these commercial properties, which in themselves are losing value daily because of the economy and before COVID. This is even worse for the banks at the moment. They're the biggest owners of buildings in the country, are the banks, obviously. So they don't want the value of the properties to be low, and obviously there's a very important ramification. So I would say that more than likely the bank will enter into negotiations and give you some sort of settlement proposal. But from a legal perspective, just bear it in mind that you don't have an automatic right or a force majeure right like the tenant does.
Okay, perfect. Thank you very much for that answer. Cheers, guys. Thanks, everyone.
Cheers.
Thanks. Josh, while I was on the line, so residential falls completely out of this thing because there's no commercial side to it whatsoever, eh?
So residential, you are still giving beneficial occupation to your students or to the tenants. So you're complying with your obligation in terms of the lease. Commercial face a bigger problem because Fluxmans, for example, can't lawfully occupy our premises right now. So there's no beneficial occupation being granted by our landlord. Therefore, there's a claim under force majeure for us to say that there's no reason to pay our rent. Your students wouldn't have that. They are being given beneficial occupation, probably more so than ever right now. And so you've complied with your obligations and you are 100% entitled to your rental.
Okay, great. No, that's what I thought the answer was, and I did some investigation obviously before this, and sure. I'm happy when they're starting to send me letters that they can't pay as a result of this. Yes, maybe they've got other circumstances, but I haven't restricted them and I haven't taken away any of their rights.
Absolutely. You might have some sympathy if they're good tenants and they might say to you they've been let off from their business or they're facing some sort of commercial difficulty. You might agree to some sort of payment holiday. Maybe they don't have to pay rent this month and then you add on a few months to the lease or something like that. But just know from a legal perspective, you are 100% entitled to claim your rent. This has not affected your rights whatsoever.